Red Flags Rising is not legal advice, nor is it legal advertising. The views expressed in Red Flags Rising are solely our own. Enjoy. Welcome to Red Flags Rising. My name is Mike Huneke. I'm a partner with Morgan Lewis in the International Trade and National Security Practice. With me yet again is my great friend Brent Carlson of Red Flags Rising Solutions, LLC. Brent, today is Tuesday, October 28th, just around 4:30 p.m. U.S. Eastern Time. How are you doing today, Brent?
Thanks, Mike. Glad to be here and discuss these important topics as always.
So, Brent, now that we're in the era of high probability enforcement, very squarely and firmly following the recent enforcement action we've talked about a few times now, we thought it might be useful to companies and trade compliance professionals out there who might be midstream in the middle of a government investigation of some kind. Maybe it's a civil or administrative enforcement action by the Bureau of Industry and Security. Maybe the Department of Justice is involved. But there are some tips and pointers for companies in the middle of those things about how to successfully get to the finish line, whatever their finish line might be, but also how to cross the finish line, as they might say, run through the finish line, and do so in a way that the company is as best positioned as possible for whatever post-resolution commitments it might have. So there's lots of pitfalls for the unwary. These journeys through investigations and through post-resolution commitments are not for the weak of heart or mind, but Brent, we thought we'd cover a few key bases for people to make sure they touch as they go through those experiences.
It's very important to understand, again, the signals that are coming from the government, because you may have, let's say, an investigation that's been going on for some time, but looking at that same set of facts from a different perspective based upon the latest signals that are coming from the government, that could lead you down certain paths. So a key thing to look at in all this is have the existing advisors or the legacy advisors raise these issues on the high probability standard, on the full definition of knowledge under the export administration regulations. Has that been incorporated into the compliance program? In the investigation itself, how are these addressed? And what are the questions that have been coming from the government? Have the questions evolved? And if you're not really sort of picking this up, and if you're not looking at this from this new high probability lens, then you're probably getting yourself into a situation where it's going to cause more problems. The first rule of self-defense is don't be there. And make sure your compliance program is incorporating all the latest guidance that is coming from the government so you stay ahead of these issues. I think that's really important. Keep that in mind.
It's very unusual for the government to announce an entirely new perspective on enforcement or policy in the middle of negotiations with the company it's investigating. Companies should never be surprised. Companies and their counsel are free to disagree with the government and to argue with them about it, but it should be something that's anticipated. There's also nothing more damaging to the efficacy of an investigation than conducting an initial stage of the investigation without looking at the right facts and without thinking about the right legal standards that might apply. You really can't get second chances when you're doing interviews of employees. The government is always going to be skeptical if you try to do basically a redo interview, and the government's not going to want you to do a redo of interviews they might have done. It is critically important to understand not only what the letter of the law says, but where the enforcement winds are blowing when you are scoping and executing an internal investigation. The integrity of the investigation is a critical factor in the government's willingness to trust the company's own fact-finding. There's nothing more costly than going back over documents that have already been reviewed, but with a new perspective about what the law means. Having to do that undermines the overall integrity of the investigation from the government's perspective as a basis for a resolution. The government's always going to want to kick the tires to some extent or another with its own fact-finding, and obviously they have tools that companies might not have access to do that, or to round out the facts that companies provide them. But if the initial investigation didn't ask the right questions, or if a later subsequent review by the government identifies facts that were sitting in the company's possession, that were hiding in plain sight, but were not brought to the surface because the right questions were not asked, or the right data was not mined, or the right people were not interviewed, then not only is the company going to be expected to essentially redo what was likely a significant amount of work that now it turns out was wasted, but the government is going to start taking a harder view view of the company's intentions, of the company's status as a good corporate citizen, you're going to be put on the heels of your feet rather than leaning into and towards an effective and efficient resolution of these matters.
Yeah, absolutely. One of the things that we see in this era of high probability compliance and enforcement is an uptake in enforcement. BIS has been signaling this for a very long time, and now you're starting to see some fruit of that action with that $140 million settlement that was just a couple months ago. I think there's more coming through the pipeline. There's a lot more activity that would be considered really pre-enforcement activity. We've seen increases in outreach visits and also the issuances of administrative subpoenas. So we're entering a whole new era where it's very different from before. There may be investigations that are ongoing and may have been ongoing for some time, but now we're getting to the point where, okay, now in this new era of high probability compliance and enforcement, how is that going to impact the investigation, what the government's going to be looking and asking for, and how as a company we can successfully get through it and get to that finish line and beyond, which we'll talk about, in the most effective and efficient manner.
Brent, these investigations can take some time, even when it's a government priority, even when cooperating with an investigation is a company priority. If you're listening to us and your company is under investigation and you get a sense that management, the board, the C-suite are all finding the investigation to be frustrating and that it's taking too long, or that there really isn't a whole lot of feedback coming out of the government in terms of what more the company can expect in terms of timing or next steps, it might be a good time to take a fresh look at how you've been interacting with the government, how you've been maybe disagreeing with the government. Maybe there's some disputes between you and the government about what the law is or what should be most relevant to the investigation. Typically, when a company is cooperating with the government, there's some dance that company and its counsel go through with the government to see what it is that the government is really most interested in, and where the company and the government are aligned on what the government should be the most interested in. Obviously, you're going to have a much more streamlined process, or at least a more collaborative process than if you might be in a situation where the company and the government are disagreeing about what the government should be interested in. To be able to meet the government, at least part way, or to work with the government collaboratively through an investigative process, it's therefore really important to understand what signals does the government think it's been broadcasting about its current view of its priorities and how it intends to apply the law. The recent emphasis by the government of the high probability awareness standard as part of the full definition of knowledge is obviously an area where if you aren't necessarily on board with the government where they're going in that direction, that could create a lot of difficulties, because from the government's view, they're more interested in circumstantial things. They might be more interested in what other people in the company outside of trade compliance knew. There may be a temptation to treat this like a litigation, where maybe you disagree with the government's interpretation of the knowledge definition, or maybe the government's approach might be different than the one that you and your legacy advisors have previously been taking. If there's a fundamental disagreement, you may find it very difficult to steer the investigation in a collaborative way to its quickest and hopefully most efficient and most fair outcome.
And steer the investigation not just in a collaborative way, but in the most constructive way as well. Mike, you make a really good point. Don't think of this as a litigation where we're going to be at odds with the government. In a litigation, the other side doesn't have the power to deny export privileges if they really get fed up and tired with you. There's a point where, yes, okay, you want to also help the government so that it's not just a wild goose chase. That's not their intention for this either.
Consistent with some of the ideas we've written about a few times, especially in the NYU Law School's program on corporate compliance and enforcement blog, which is about to publish, Brent, your next piece, and I'm looking forward to reading it there. We'll put a link in the show notes when it comes out. It might be an opportunity for you to demonstrate how you can think creatively about what data you do have in your possession and what does that data show. It may not be super obvious if you look at that data in a static way at a particular point in time, but it would be worth considering whether that data shows changes over time. As we've often talked about, Brent, holistic and dynamic changes that would be a reliable starting point for making inferences about what was happening. That could be extremely valuable to the government. It could be extremely valuable to trade compliance professionals on a going forward basis as well.
Absolutely. And this goes back to that theme that we've been talking about, the era of high probability compliance and enforcement. By leveraging the full definition of knowledge under the Export Administration Regulations, which includes not only actual knowledge but an awareness of a high probability, this allows BIS to bring more cases, resolve them faster, and with higher penalties. Thinking about how this game has changed is very important. That's why we have to take new approaches, new strategies for new challenges.
Brent, the point on mid-investigation strategies, especially where you might be frustrated, is to go back to first principles of any type of white-collar representation. The first principle is do no further harm. Make sure that when your people are receiving the government at your locations, when they are responding to requests from the government for information, when they are sending data to the government, when they are speaking to the government, especially if you're making employees available to be interviewed, that people understand that in white-collar enforcement, it's often not the original crime itself that gets people in trouble, it's the cover-up. For example, just over the summer, there was a case involving the theft of intellectual property and exporting of that property to another country. The charges in that case include false statements based on the interviewed employee's initial denials to the FBI about the transfers of this technology. In America, you always have the right to remain silent, and you always have the right to ask that an attorney be present. It's much better to do those and then cooperate fully afterwards than to feel like you have to succumb to the pressure of the moment and say things that might sound like what your gut wants you to say right away, but what may end up just digging a deeper hole for you.
If there's an investigation, let's say you're at a company and it's something ongoing for a couple of years already now, look for and be very highly attuned to questions from the government that may imply or reflect this new high probability enforcement world that we live in. Pay attention to those signals. If you've got people in the room that are not quite attuned to that, then you may want to get a second opinion and just bounce what you're seeing and hearing off some others that may be able to provide some help and avoid a big landmine or big potential liability pitfall that you may have not seen coming based on legacy assumptions. For example, entity shifting. If you had a customer that went on the entity list, then all of a sudden some white knight came out of the woodwork buying the same stuff, same volume, and there are connections, i.e. red flags between those two, then that's something to address. You want to get in front of that. Like you said, Mike, one of the first principles is do no further harm.
On the idea of a second opinion there, Brent, one other thing to consider is, look, at some point, the reason you engage, especially an external lawyer for support, is that the advice you get is going to be protected by the attorney-client privilege. The value of that is that you can blame the lawyer later if you need to. So keep that in mind. If you have advice from a legacy advisor, that could be a very valuable tool in a defense to the company that you can deploy the longer you allow the government to proceed down a path with the idea that you were acting either unadvised or with an incorrect view of the law. That's going to further and further frame and anchor the government's view of you as a company, fairly or not. And we often say that because a lot of times life is unfair, especially in white-collar enforcement. That's going to have an impact on how the investigation progresses, how much the government feels comfortable relying on proffers and other assertions from you and your counsel. How long that investigation lasts is going to influence significantly the cost of the investigation to you and the impact and disruption on your business operations because of the investigation. Now, if you do that, it might get a little uncomfortable or even create a conflict of interest to have then that legacy advisor still defend you in the investigation if you're going to waive privilege over prior advice that they gave you. So as much as I want to support the legal profession, we do not need the charity of paying us to do an investigation caused by bad prior advice that then you don't waive, and so it never becomes an issue. Brent, we've talked a bit now about running up to the line of trying to conclude an investigation. Let's say you're at the conclusion of an investigation and you're reaching a resolution with the government. When you're looking at the proposed settlement agreement with BIS, some kind of resolution with DOJ, hopefully not a plea agreement if you can avoid it, maybe a deferred prosecution, non-prosecution agreement. It's very important to think about how are those agreements going to protect you in the future. Not even necessarily from future misconduct, because typically what happens in the real world is that these agreements are reached based upon commitments by the organization to increase its spend and its commitment to compliance and to be able to satisfy the government that it has done so. But the real danger is what happens when past misconduct becomes known to the government, either because of a whistleblower allegation, because of a media report. How are you protected against that conduct? Brent, in my own experience with the FCPA, I've seen dramatically different outcomes under dramatically different agreements. I've seen situations where a deferred prosecution agreement contained no acknowledgement of broader issues. It didn't explain that there was some kind of underlying compliance misunderstanding or misreading of the law that might then be cover for the later disclosure of further prior misconduct. So if that is really the case, and especially look, if the administration changes or the prosecutors involved get promoted or move to private practice or otherwise change jobs, the government's going to be upset that there was prior misconduct that was not disclosed to it, and the current agreement might not give you any cover for that. On the other hand, if you're able to reach an agreement that gives you cover for maybe generalized, unspecific past misconduct, then that could be an extremely valuable thing, especially if there are new executives involved going forward, especially if there's new legal and compliance people involved going forward. If you're going to get in a situation where you think you have some kind of informal understanding, but it's not in writing, if you get into a government said, company said dispute where there's something that has come out that's very embarrassing to the government and very detrimental to the company is never going to win that debate with the DOJ. That's not an argument you're going to win, certainly not one you should expect to win.
So I think this is very interesting because you raised some interesting points where if we're a company thinking about how we should get to this resolution, and we've come to the end of the investigation, and I think everybody has a sort of investigation fatigue by the time they get to that point. Number one, just stay strong and keep in the race because it's not fully over, right? Even at the point of when the settlement or the plea agreement gets signed, then it's still a whole new ball game.
To me, that's the key thing. If I was a chief legal officer, if I was a general counsel, frankly, if I was a member of the board of directors, I would want to hear specifically from my advisors, how does this protect us when invariably there's at least some allegation that comes out post-resolution about pre-resolution conduct? Are we covered? And if you're not, figure out a way to get covered, because there's no better time than when you're about to wrap up an agreement and people are coming to a conclusion about how to resolve this to make sure you're getting that protection as well. Might it mean that you have to pay a little bit extra money and that maybe some things take a little bit more time to resolve? Yes, but getting that resolved while you're in a collaborative and cooperative posture with the government is, frankly, to me, invaluable.
It's sort of like an exercise program. The best time to start an exercise program was 20 years ago. Well, when's the second best time? Today. So especially if you're in a situation where the chief legal officer, an officer at the company, is going to have to certify that the company has met its obligations and is in full compliance with export controls, think carefully about that, especially in this new high probability era. It's like, has that been incorporated before? Has that been addressed before? And if not, the second best time is today. Take care of that now before it comes up and blows up.
You're absolutely right, Brent, to mention that self-certification. It's a relatively new development in the world of white-collar corporate enforcement. When you're in a situation where the DOJ is involved and you're not going to get a declination or a non-prosecution agreement, you're staring at a deferred prosecution agreement or a guilty plea, it's extremely important for the officers involved to think, who is certifying what in the future? It raises a ton of questions that need to be carefully considered. If there's a requirement that a corporate officer sign a certification, what is the certification about? Typically, it's going to be about two things: that the company cooperated as it was required to in making disclosures to the U.S. government, and that the company has in place an effective compliance program. How is a CEO, how is a chief compliance officer, how's a general counsel going to make that determination? If you think about the difficulty of just implementing any compliance program and an otherwise friendly and law-abiding company of any size, making that certification is no small thing. On what facts is that decision going to be made? Are you going to require, like you might see in Sarbanes-Oxley compliance, for example, sub-certifications? On what basis are those going to be made? A strategy for dealing with that would be why the high probability standard works from both a compliance process and not just an enforcement process. It invites you to create an objective framework within which you make subjective decisions in a consistent manner. And you basically have to apply the same principle to your decision whether or not to self-certify.
Yeah, absolutely. It's worse if things come out that should have been addressed before. In terms of solutions, well, again, the first rule of self-defense is don't be there. So don't get yourself into that position. Let's say the investigation was ongoing and then you came into a company and had to take it over. Well, then understand, okay, let's take a look at exactly what was done. Is there other activity here that didn't get disclosed or make it up the flagpole? Well, let's get ahead of that because it's not going to go away. It's sort of like being on double secret probation for a while. You have to play ball. You have to play by by those rules and be highly attentive to where those potential risks may be, because at that point, they're not just risks. Those could be real liability landmines, if not ticking time bombs.
Absolutely. The other thing to make sure you are crystal clear on is if there is a monitor, if there's an independent compliance consultant, are they monitoring what matters? And Brent, we wrote an article with the NYU PCCE blog a few years ago specifically on this topic. We'll link it in the show notes. In the context of an export controls violation, our view is that the monitor or the independent consultant shouldn't be spending years spending a lot of the company's money, because that's whose money gets spent, looking at things that don't really move the needle in terms of actual national security risks, in terms of actual export control risk. For example, doing some kind of audit of every license application you've ever applied for in the last 10 years or 5 years would be unlikely to do anything other than cause a bunch of money to be spent cataloging those applications. Instead, monitors or independent compliance consultants in this space should really be asked and expected to tailor their work plans in a very focused way on the root causes of the misconduct that led to the settlement. They should be themselves using the high probability standard to focus on the types of relationships, the types of products, the types of end uses and end users that really drive real export control risk. If a monitor did that, if an independent compliance consultant did that, you would avoid the situation that has caused a lot of justifiable criticism of the use of corporate monitors in the past, where they spend 5 years and $50 million of the company's money engaging in extravagant industrial tourism. Our view, Brent, is that you could have an export control independent compliance consultant come in and in really a matter of months zero in on the key relationships, let's say it's distributors and resellers, depending on how the particular company goes to market and through whom and where, and use the principles that we've outlined in the other NYU PCC articles to scope and execute a very defensible review that is, in our view, most likely to actually get at the real national security problems. Companies and the government would benefit from this. It's less money from the company's perspective. It can be done in much less time instead of a 3-year monitorship or a 3-year audit. If you really know what you're doing and the company and the government are both on board and very cooperative, this is something where you do an initial review in the first 6 months.
Yep.
You let the company run on its own for another couple months, and then you do a kind of sanity check at the end of 12, and then you move on.
Yes.
That allows everybody to move on to the next thing, both from a commercial and from a government investigative sense. This would be a way that the government could leverage the expertise of monitors and independent compliance consultants as a force multiplier for good, and not just for, as I said, industrial tourism or to waste the company's revenue.
Mike, that old monitor structure that we saw in the FCPA days is not going to work here in the export controls world, in this geopolitically charged environment that we live in with national security implications. That just takes way too long.
The objective of a monitorship, the objective of any independent compliance consultant should not be to hold the company to an unobtainable, unachievable standard that it could only meet by continuing to engage someone acting like the monitor in perpetuity. The objective of those mechanisms should be to help the company adopt and implement a right-sized, risk-based, and achievable framework for effectively mitigating national security risk going forward. That's the objective. As much as you and I would like to be monitors for 12, 15, 20 years, Brent, that's not going to help anyone. That doesn't help the United States of America. That's not what our national security objectives are. This would be another place where I think where government and industry can build trust with each other by where they do have that independent requirement. It's actually tailored and aggressively scoped, work planned, and executed to get the company to a point where it can achieve with internal resources in a normal day-to-day environment the standards that both it and the government want to meet.
If we all stay focused and we're paying attention to the right issues, we can get through all this as quickly, efficiently, and economically as possible.
Well, Brent, that brings us to managing up backed by overwhelming public demand. What's your managing up for this episode?
Yeah, investigations can bring a lot of Sturm und Drang to companies, a lot of distraction, a lot of stress. It's natural to feel some bit of investigation fatigue. It's important, though, to remember just to stay strong because it's a marathon, not a sprint. Getting to that finish line of the settlement agreement is actually not the finish line. You have to keep running through the finish line to get to the very end. The post-settlement period represents a new chapter, a whole new ball game that needs to be played as thoughtfully, strategically, and focused as the investigation part leading up to it. Keep that in mind. It's not over till it's over. It can be even a more critical point because the worst thing is to have more issues of past actions come to light that should have been addressed. If there's any potential there, get on it. Get on it right now before it becomes an issue. It's easy to think, well, okay, we can put this off for another year. Do it now. You'll sleep a lot better.
It's important to keep your head up, shoulders up, maintain your breathing, and keep running through that finish line until you get to the end of the resolution. Well, Brent, that concludes this episode of Red Flags Rising. As always, it's been a pleasure. Be well.
Thanks, Mike. Be well. And to everyone else out there, be well.